Why the court should interview the child in a child custody dispute instead of appointing a guardian ad litem or PGAL. And saying PGAL is very hard, so I'm just going to say GAL, but I mean the same thing. Now, before or after you read this blog post or listen to this video, you may want to read this other blog post that I provided in the video description section about why appointing PGALs to represent children in child custody disputes is such a terrible idea. Interviewing the children directly for and on the record to provide the court with testimony from the minor children that is material and relevant to determining the child's best interest in the context of making the child custody and parent time awards makes far more sense than having a GAL appointed for the children. When the court interviews the children, the court has this first-hand, on-the-record evidence to consider in determining whether to modify the child custody orders or what child custody orders it may make for the first time. The children have the greatest stake in the matters of child custody. They need and deserve to be heard and on the record. Subserving their best interest requires that the court consider what the children have to say regarding their experiences, observations, feelings, opinions, desires, and ideas in determining the outcome of the child custody dispute. Children have their own voice, voices that need and should be heard directly, not filtered, adulterated, and summarized through any costly, time-consuming intermediaries whose recommendations cannot be corroborated with any independently verifiable proof, as is the case when you appoint a GAL. The Utah Code authorizes a court to interview children. An interview by the court is no more or less harmful to the children, if harmful at all, than an on-the-record interview conducted by a GAL. While a mental health professional may have a softer touch or some greater skill in conducting a child interview, that does not justify the cost, the time, the expense, and the utter lack of actual evidence the appointment of a GAL does not yield. There is no legal presumption, because there is no evidence, that the children generally, or the children in a particular case, are so psychologically or emotionally delicate that being interviewed on the record would do them more harm than good. It may be helpful to enlist the help of a therapist to help the court assess the situation and needs of the children, or maybe in the phrasing of questions if the court is so inclined. It may be helpful to consider their recommendations too. But to suggest that the court's interview of the children inherently would have no value or would be inherently harmful to children is patently false. How could it be otherwise? An interview of the children by the court is not just an additional data point for the court to consider in analyzing and determining what action by the court is in the children's best interest. It is indisputably crucial, arguably the most crucial, in analyzing and determining what action by the court is in the children's best interest. If it is determined that the children are fit to be interviewed by a GAL or custody evaluator, no one can, in intellectual or ethical honesty, make a valid argument that the interviews should not be on the record, or make a valid argument that a judge or commissioner cannot or should not interview the child. If the court feels it would benefit from the children being interviewed, then the most important interview needs to be by the one conducted by the court itself. Other interviews by a GAL or a custody evaluator, or others perhaps, should be on the record anyway. And these may be helpful or benign, but to argue that anyone but the court can or should interview the children is patently without merit.